Hello and a very warm welcome to the Analyst dated 26 August 2025, brought to you by Vajiram and Ravi, wherein we'll be covering the 7 set of current affairs issues which have featured in today's newspaper. The handout of this very discussion is available in the description below for your future reference. Beginning with the analysis section, as in the backdrop of insensitive jokes being made against the persons with disability on India's Got Latent show. In this backdrop, the Supreme Court has asked the central government to create a regulatory framework to regulate the conduct of social media influencers. And while doing so, the government has to strike a fine balance between freedom of speech and expression versus human dignity of other individuals. Moving on to the second topic, herein we'll try and understand that why the legislations being made by our parliament are ending up in the court. And why in the recent times we are seeing that the constitutional courts are emerging as parallel legislators. Moving on to the simplified section, herein we will be covering the 5 set of current affairs issues in the most simple manner possible, and we'll also be doing value addition which would be relevant for your prelims examination. So stay tuned. So beginning with the first topic, which is dealing with regulating the conduct of social media influencers. This particular topic we can relate with GS paper 3, wherein we have the topic media and social networking sites, and you can also relate it with GS paper 2, wherein you have the topic vulnerable sections. Now what is the context? Recently, in India's Got Latent show, one of the comedian has made insensitive jokes against the persons with disability. And in this backdrop, Supreme Court has asked the union government that can we consider creating a regulatory framework so that we can regulate the conduct of these social media influencers, wherein whatever harm they are doing to different sections of the Indian society, in proportion to that, there should be adequate consequences for the same. Now, let's just understand that what was the background of the case. So, the comedian, that is Samir Rana, in his India's Got Latent show has made insensitive jokes about persons with disability. So that is the reason the Supreme Court has asked the union government that let's just come up with the regulatory framework. Let's just regulate the conduct of the social media influencers. We need to regulate the obscene online content which is also being circulated on social media platforms. We need to regulate the online shows like the podcast, and this needs to be done in consultation with the National Broadcasters and Digital Association. Now, in this particular backdrop, the comedian Samir Rana has stated that he will be coordinating with the concerned authorities, and he is also going to apologize for the insensitive jokes that he has made against the persons with disability. Now, the first thing that we need to understand with respect to this particular context is, why do we need to regulate the online content which is there on social media platforms, and why there is a need to regulate the conduct of social media influencers? Now, first and foremost thing that we need to understand is, when it comes to these social media influencers, they are, at the end of the day, they are commercializing their freedom of speech and expression, which is provided under Article 19, Clause 1, Subclause A. But this fundamental rights does not give them the right that they can hurt the sentiments of the diverse sections of the Indian society. And that is the reason Supreme Court says that we need to regulate the conduct of social media influencers. We need to protect the creative freedom of the social media influencers, and that is the reason the Supreme Court has stated that whatever regulatory framework that will be coming up, to regulate the conduct of social media influencers, while doing so, we need to strike a very fine balance between preserving freedom of speech and expression of these artists, ultimately preserving creative freedom, and we need to also make sure that we are balancing it with the dignified life of other sections of the Indian society. The media influencers do not get the right that they can hurt the sentiments of diverse sections of the Indian society. So this is the first thing that we need to understand, because India is a very diverse country. Now, second important thing that we need to understand is, these social media influencers are playing a very great role when it comes to shaping the societal norms. Why I am saying this? Because if you go by this particular, survey by the Telecom Ministry in 2025, what we are seeing that more than 80% of the households, they have access to internet. That means majority of the people are having access to the social media websites and the content which is circulating on them. In ethics, you must have read the CAB model of attitude. So C is basically the cognitive part, what you are thinking. And ultimately this cognitive aspect is going to shape your behavior. And as Mahatma Gandhi says, that what a person thinks, he ultimately becomes. Now, just imagine the scenario. Time and again, I am seeing a content which is objectifying women or which is normalizing violence against women. Whatever I'm consuming, this is going to impact my cognitive aspect. And ultimately, over a period of time, what would happen? This is going to shape my behavior. For me, violence against women would be a normal thing. So that is the reason Supreme Court pointed out that we need to regulate the content which is there on the social media websites, and we need to regulate the conduct of social media influencers, because what influencers say, it matters. It influences an entire generation. It might happen that when it comes to a child, if a child is seeing obscene content time and again, his understanding of healthy relationship and sexuality might be altered. So since they have a great role to play when it comes to shaping the societal norms, ultimately the behavior of a larger section of the Indian society, we need to regulate their conduct. Then it is very much pertinent to protect the interest of the vulnerable sections, because the content which is being circulated on social media website might be altering a child's understanding of healthy relationships and sexuality. It might be going against the interest of the woman, objectifying women. And social media websites, fake news, etc. might create issues for the minority sections. Okay, it might, aggravate the social divisions which are there in the Indian society. For example, this Bully Buy app was sharing the images of women, and the images of women were auctioned online. So this is what? This is going against the dignified life of women. And if we are not regulating such content, ultimately this is going to alter the societal norms and ultimately behavior. Then we need to regulate their conduct. This would be in line with the J.S. Mill harm principle. What does this say? That if you have the liberty, in the Indian Constitution, we have got this freedom of speech and expression under Article 19, Clause 1, Subclause A. But this liberty does not gives me the power that I can do harm to other individuals. If I am doing that, it is going against this J.S. Mill harm principle. And this J.S. Mill harm principle clearly states that if an individual is misusing its liberty, then consequences should be there, but those consequences, whatever penalty you're going to impose on that particular individual, which is misusing his or her liberty to do harm to another individual, so the penalty that we are going to impose on that individual should be in proportion to the harm that he or she has done to other individual. Okay, and that is what Supreme Court has also pointed out in this recent verdict. Okay, that the consequences should be in proportion to the harm that they are causing to the different sections of the Indian society. Then, if we don't regulate the online content which is there on social media platform, that could lead to polarization. Fake news leads to mob lynching. How fake news can create communal tensions? This is something that we have witnessed in West Bengal, Murshidabad district. Then the social media influencers, why we need to regulate their conduct? Because they are the one who are promoting mindless consumption. Even when they have not used that particular brand, product personally, then also they are promoting it just to get some amount of money. Now, when the social media influencers are idolizing a particular way of life, that is giving boost to consumerism, mindless consumption, this goes against the Gandhian ethics of self-restraint. This also goes against the idea of sustainability. Okay? Minimalistic approach. And this social media influencers, when they idolize a way of life, don't you think so? It is creating a kind of mental health issues also. Why? Because majority section of the Indian society, we are not able to attain that idealized life. Talk in terms of body shaping. So these social media influencers, they would be showing that, okay, this is what a perfect body looks like. And that ultimately impacts the mental health of a person who is suffering with obesity. Or maybe he or she must be have gained weight because of one or the other reason, because maybe of pregnancy, because of certain diseases. And that leads to low self-esteem when it comes to that particular person. Why? Because social media influencers are idealizing a particular way of life. So this is the reason why we need to regulate the conduct of social media influencers as well as the content which is there on online platforms. Now, let's just understand that what all regulatory framework we have in place to ensure the accountability of social media influencers. So we have the Central Consumer Protection Authority, which would be looking into all the cases wherein consumer rights are being violated, wherever there is unfair trade practices are being carried forward, and false or misleading advertisements are there. Then we have SEBI, which has recently banned certain unregistered fin influencers. For example, Ashmita Patel Global School. So these people, they don't have any technical background, and then also they were giving you free advice on the social media platform. Fin influencers are those which gives you financial advice with respect to investment in stocks. Okay, so SEBI has taken action against these unregistered fin influencers, and this has been done to protect the investors' interest. And SEBI has also come up with a guideline, and it has stated in that the fin influencers, they need to register themselves with SEBI. Then we have Advertising Standard Council of India, which has clearly outlined that if a social media influencer is endorsing a brand and if it is a paid promotion, then they need to clearly outline that in the advertisement that yes, it is a paid promotion. Then the Department of Consumer Affairs, in order to ensure ethical practices when it comes to endorsement of the brands, it has published endorsement know-hows. Okay, so under this, what the Department of Consumer Affairs have stated that if you are doing a paid promotion, you need to clearly explicitly mention that in the advertisement. And the celebrities, the social media influencers, they need to exercise due diligence if they have not used that particular product on a personal level. Okay, so these are the guidelines which have been outlined in the endorsement know-hows. Then we have India Influencer Governing Council, which is a self-governing body which has been created by the industry itself. And it has introduced a code of standards and a weekly influencer rating. Weekly influencer rating, if a social media influencer is coming up with ethical conduct and is abiding with this code of standard, automatically the ratings would be improved. What is there in code of standards? Again, you have to explicitly outline if it is a paid promotion. You have to make sure that whatever content you are creating on the online media platform, that is safe for the children. And there is also a complaint forum. Okay, if the consumers have any complaint with respect to whatever content is there or conduct of social media influencers, then the consumers can register their complaint. Okay, and this particular code of conduct also says that at one time, social media influencers cannot endorse two competing brands. Okay, this actually confuses the consumers at the end of the day. We have a regulatory framework to regulate the online content as well. So we have the IT Act, we have IT Act rules also, under which the Ministry of Information and Broadcasting has been given this particular power, that they are the one who have to regulate the OTT platforms and the digital news media websites. Then we also have POCSO Act, which regulates the obscene content which is dealing with children. Then we also have Indecent Representation of Women Prohibition Act, as the name itself suggests, that whatever content is representing women in an objectifying manner or it is going against the dignity of a woman, that content should not be circulated on social media platform. Now, having understood the regulatory framework that is there to ensure the accountability of social media influencers and the regulatory framework that we have to regulate the obscene online content, what all challenges we are still witnessing when it comes to regulating the content as well as ensuring the accountability of social media influencers? First and foremost is the coordination issue. Now, it is Ministry of Electronics and Information Technology which frames the IT rules. But right now we discuss that under these rules, which Ministry has been given the power to regulate the digital news media platform as well as OTT platform. So it is the Ministry of Information and Broadcasting. So that creates coordination issues between the two entities. Then there is huge subjectivity involved when it comes to definition. How you are going to define that what is exactly an obscene content? It is subjective. For some person, maybe one content is obscene, but for the other person, the same content is not that much obscene. Okay, especially the people who are guided by homonormativity. Okay, they might be seeing that any movie which is dealing with LGBT community, that movie might be obscene for them. So huge subjectivity is there when it comes to defining what do we mean by obscene content. So that creates regulatory challenges, that which content should be regulated or not. Okay, and at times might lead to harsh action being taken by the government because the definition is not clear. Then technological challenges are also there. For example, end-to-end encryption, privacy features of WhatsApp. Now, whatever obscene content is circulating on the social media platform, it is very difficult for the regulatory authorities to track that. Then the same is the issue with virtual private networks. Virtual private networks enable you to access unauthorized content as well as unauthorized websites, okay, and the regulatory authorities would not at time be able to track your IP address. Okay, so this enables you to bypass the regulatory oversight. Now, another challenge that we are witnessing at the technological front is the feedback loop which is there in social media algorithms. Now, let's suppose once I was exposed to an obscene content, that in that content we were objectifying women. Now, because of this feedback loop, what would happen? Time and again, similar kind of content would be shown to me. And this would be impacting what? My cognition. Ultimately, my attitude and behavior. Okay? So, this is problematic. Then, another challenge is how do we strike a fine balance between protecting the freedom of speech and expression of the content creators, preserving the creative freedom of the artist. At the same time, how do we protect the fundamental rights or ensuring dignified life to other sections of the Indian society? Maintaining that fine balance is a tough task. Now, in this backdrop, we need to understand that what more needs to be done. So first and foremost, as the Supreme Court has clearly stated today itself, that we need to set clear responsibility. Going by the J.S. Mill harm principle, in proportion to the harm that they have caused to other sections of the Indian society, in the same proportion, the penalty should be imposed on them. Okay, we cannot leave such social media influencers every time by just giving a formal, warning. Proper penalty should be there if they are causing or hurting the sentiments of other sections of the Indian society. Then we can use the technology. For example, we can use AI-powered content analysis to filter out the content which is obscene, to filter out the content which is, having false narratives, etc. Then we need to strengthen self-regulation. In ethics, you must have read the limitations of laws. Laws are a kind of external force. They do not lead to lasting internal motivation for change. For that, self-regulation is the way forward. So, the social media websites, they need to come together and they need to put in place a self-regulatory mechanism. This would make sure that their creative freedom are protected, and this would prevent, unnecessary interference from the government when it comes to the content that they are creating. So this is a win-win situation for the government as well as the social media intermediaries. Then we need to promote media literacy. It should be a part of the curriculum at the school level as well as at the college level. Why? So that a child understand that what is a good content and what is a bad content. Because if the child does not understand that how to differentiate between these two kind of content, that could lead to altering his or her narrative when it comes to healthy relationship, sexuality, etc. and how it can badly impact their cognition. So that is the reason we need to promote media literacy from the school itself. Then at the end of the day, the content creators need to make sure that they are creating value-based and responsible content. Why? Because see, at the end of the day, for any corporate entity to perform better in the long run, you need to follow the ethical standards. That would prevent or protect you from any legal or regulatory consequences, and in the long run you will be able to build a brand value, and you will be able to enjoy the consumer satisfaction at the end of the day. Okay, so in this light, the social media influencers should come up, and they should come up with the ethical conduct. They should make sure that whatever content they are creating, that is meeting to certain ethical standards. That would only enable them to earn a brand value in the long run. That's all that we need to discuss with regard to this particular topic. I have framed a practice question for you. So based on the discussion, please try and practice this particular question. With this, let's move on to the next topic. Now, the second topic is talking about that why the laws being created by the parliament are ending up in courts, and why in the recent time we are seeing that the constitutional courts are emerging as parallel legislators. This particular topic you can associate with functioning of parliament and state legislatures. Now, the article firstly talks about the sovereignty of parliament. Okay, that is not the case when it comes to India, and sovereignty of parliament is something that we associate with the UK parliamentary system. Let's just understand what do we mean by sovereignty of parliament. So when you talk about UK parliament, it can make, amend, substitute or repeal any law. It is said that the UK parliament can do anything except making a man a woman. Okay, so it has such wide powers. Then when it comes to the constituent powers and the ordinary legislation powers of UK parliament, there is no difference between the two. Constituent powers basically means that what procedure you are going to follow to introduce a constitutional amendment bill. Okay, and what kind of majority the parliament need to pass a constitutional amendment bill, and that needs to be different from the majority that we need to pass a ordinary legislation. But there is no such distinction when it comes to the UK parliament. Then whatever laws have been made by the UK parliament, they cannot be declared as void by the judiciary there. These are the reason why UK parliament is said to be sovereign. But when it comes to the sovereignty of Indian parliament, that is quite limited. Why? Let's explore the reasons. First and foremost, we have a written constitution. So the constitution has clearly set the boundaries for the central government as well as state government. And in the constitution, we have different procedure to pass a constitutional amendment bill and to pass a ordinary legislation. For ordinary legislation, you need simple majority. For constituent, bill, for constitutional amendment bill, we need special majority under Article 368. And if it is going to tweak the federal features, then we also need ratification from half of the state legislatures. You need to let me know in the comment section that state legislatures ratify the constitutional amendment bill by what kind of majority? Is it special majority or is it simple majority? Then moving forward, we have federal system of government, but in UK they have unitary system. Okay, so the constitution has clearly created two divisions of government. One is the central government, the other one is the state government, and the powers of both level of government has been clearly outlined in the 7th schedule. So the legislature at the union level, they can only make laws with respect to the union list, concurrent list and the residuary list. They cannot make laws when it comes to the subjects which are mentioned in the state list, except in 5 exceptional circumstances. What are those circumstances? If Rajya Sabha passes a resolution, okay, backed by 2/3 majority of the members present and voting, if national emergency is in force, precedent rule is in force in that particular state to give effect to international agreements and treaties, or if 2 or more states make a request to the parliament that you please make a law on this particular subject which is there in the state list. Then fundamental rights, Article 13 clearly states that the parliament does not have the power to make any law which violates the fundamental rights, and even if they make it, it would be declared as void by the courts, because we have system of judicial review in case of India. So it is the judiciary which looks into that whatever laws have been made by the legislature is in compliance with the constitutional provisions or not. If that is not the case, the judiciary can declare that particular law null and void. But what we are seeing nowadays is this judicial review power was supposed to be used exceptional, okay, in exceptional situation. But nowadays it has become a norm. Majority of the laws being passed by the parliament are ending up in the court. They are being scrutinized by the constitutional court, and that is the reason the writer is making a very strong argument that in the recent time we are seeing that the constitutional courts have been elevated to the status of parallel legislators. Let's just understand why this is the scenario. And to validate this particular argument, writer has quoted the data also. This data was given by Union Law Minister in Rajya Sabha in 2022 that 35 cases challenging central legislations and different constitutional amendment acts are pending before the Supreme Court since 2016. So from this very data, we can very well see that majority of the laws which are being made by the parliament are ending up in the court. Okay. Why is it so? Why the laws made by the parliament are clogging Indian courts? First and foremost, when it comes to the laws being made by the parliament, they lack constitutional or legal precision. They have vague definitions, and whenever a law is being made, the parliamentarians are not doing cross-reference with other, provisions of the constitution, with other law which is there in place. And this we can validate by this particular example. If you go by section 18, clause D of Transgender Persons Protection of Rights Act of 2019, if a sexual abuse is done against a transgender person, then in that case, maximum punishment is only of 2 years imprisonment or fine. But if you go by the Bharatiya Nyaya Sanhita, if there is sexual abuse against a woman, then the penalty would be imprisonment for 7 years or life imprisonment. So this is contradictory, and this again might be ending up in the court. So whenever the parliamentarians are making a law, they need to do cross-reference with other laws or legislation which are there in place. Then they are not following the parliamentary procedures, which is clearly outlined in the Manual of Parliamentary Procedure. So what we are seeing is bill are being introduced without giving adequate notice to the parliamentarians, and the bills are not being referred to the parliamentarian committees. What we are seeing in the 15th Lok Sabha, more than 60% of the bills were referred to parliamentary committees. 16th Lok Sabha, roughly 25%, and the 17th Lok Sabha, merely 16% of the bills are being referred. Now, why referring the bills to the parliamentary committees is crucial? Because we read in our polity books that when it comes to the parliamentary committees, firstly, the MPs are able to give their opinions devoid of the party politics, and secondly, in the parliamentary committees, we also have this opportunity to get the advice from the experts with respect to that particular matter. So this would make sure that the definitions are not very vague and the law is not very complex. It is in simple manner because we have the expert opinion. Then lack of research support, which is there when it comes to the US parliamentarians or the UK parliamentarian, which is lacking when it comes to India. Okay. And when it comes to India, we have Article 88, which clearly states that the Attorney General of India can participate in the proceedings of both the houses, although he does not have the right to vote because he is not a member of either of the houses. Now, Attorney General of India, highest law officer when it comes to India, this article clearly states that he can be a part of the proceedings, but this thing really happens. And that is the reason we end up making very complex legislations, and ultimately that is clogging the Indian courts. Then anti-defection law is another problem. Ultimately, the MPs are being guided by whatever direction the party whip is issuing to them. They are not voicing their true concerns with regard to a particular legislation, although they are supposed to act as the representatives of the people who have elected that particular representative. But at the end of the day, what we are seeing that they are merely acting as a delegate of their particular political party. This is undermining the role of an individual MP when it comes to the parliamentary debates. Now, when it comes to whip, you need to understand that there are three kinds of whip. One is one-line whip, wherein the party would be telling you that on this particular date, voting is going to happen. The party whip would not be telling you that you need to be present or what should be a pattern of voting. It is up to you. Then we have two-line whip. What happens in two-line whip? Herein the party whip would be telling that, see, on this particular date, voting is going to happen and you need to be present on that particular date. Although there would not be any direction from the party whip with respect to your pattern of voting, whether you should vote for or against that particular matter. Last is 3-line whip. Herein, the party whip would be telling on this particular date, voting is going to happen, you need to be present and you need to vote in a particular pattern. So party whip would also be telling you that whether you need to vote in favor of or against of that particular issue. This is the most strictest whip. So this prevents the parliamentarians to voice their genuine concerns with regard to a particular bill. Otherwise, they would have to face anti-defection proceedings against them. Then another bone of contention is frequent disruptions that we have witnessed, which was also something that you witnessed in the recent monsoon session as well. Now, what happens because of frequent disruptions? There is decline in the time that you have for the parliamentary debates, and that is what happened in the 17th Lok Sabha. 58% of the bills were passed within 2 weeks of their introduction. Now imagine 35% of the bills being passed within less than 1 hour of discussion. So imagine what kind of laws we are creating. Ultimately, those laws would be very complex and ultimately they would be scrutinized by the court. Then, because of frequent disruptions, adequate scrutiny of the budget is not being done, and that is something that we witnessed in 2023. 75% of demand for grants was passed without discussion in the House. Then, frequent resorting to guillotine closure motion. What happens in guillotine closure motion? Wherein, because of paucity of time, the presiding officer would say that few provisions we have discussed, let's just put all the other provisions even if we have not discussed because we have paucity of time. So imagine what would be the quality of legislation that the parliament is creating, because it does not have enough time to focus upon the debates. It is frequently resorting to guillotine closure motion. So the parliamentarians do not have enough time to raise their concerns because there is paucity of time. So ultimately, we would be ending up with complex legislation. The parliamentarians do not have the adequate time that they can do the cross references or they can raise their grievances, genuine grievances with respect to a particular legislation. And that is the reason the complex legislations are ending up in courts and the court is scrutinizing their constitutionality. Now in this backdrop, what needs to be done to improve the situation and ultimately to improve the quality of legislation so that we come up with very simple laws which is in alignment with the other legislation that the parliament has created and it is in alignment with the other constitutional provisions as well. So what needs to be done in this particular backdrop? We need to increase the sitting days, as the National Commission to Review the Working of the Constitution recommended that at least for 100 days, both houses of the parliament should work. Okay, when you will be having more time, obviously, we do not need to resort to guillotine closure motion. The quality of parliamentary debates would be better and ultimately we will be coming up with better legislation which would be taking into account the interest of the diverse sections of the Indian society. Then we need to strengthen the parliamentary committee like we have in case of UK, except the money bill, all the bills are directly referred to the parliamentary committees. This practice is something that we need to adopt when it comes to India as well. Okay, because parliamentary committees, we get the expert guidance there. Then we should effectively use Article 88. The parliamentarians should seek the legal guide from the Attorney General of India. He is the highest law officer when it comes to India, and the writer has pointed out that if Attorney General of India is taking part in the proceedings of both houses of the parliament, what would happen? He would be able to flag the legal inconsistency, okay, during the parliamentary debate itself. So we will be able to come up with better legislation, ultimately not ending up in courts. And another point which the writer has pointed out, that Attorney General of India would be giving non-partisan constitutional advice. Okay, so the different political parties would be adhering to the non-partisan legal advice which would be given by the Attorney General of India. And that would also enable us to get the requisite amount of majority to pass an effective legislation. Then we need to provide legal advisory support to the parliamentarians like what we have in case of USA, like In USA, we have Congressional Budget Office, which provide the MPs with the independent analysis of fiscal policies. Okay. Until and unless the MPs do not have the requisite technical advice, they would not be able to hold the executive accountable properly. Then we need to reform the anti-defection law so that the MPs could actually act as a true representative of the voters. Okay, and in this respect, the Law Commission 170 report has clearly stated that we should restrict the application of anti-defection law only in certain crucial matters. Okay, when the passes of money bill is being considered, confidence or no confidence motion is being introduced, in rest of the matters, the individual MPs should be allowed to raise their concerns, divide of the party politics. Only then we will be able to come up with an effective legislation. And lastly, to address the issue of frequent disruptions, we need to adopt the concept of opposition days, which is there in UK. So if let's suppose the House has to meet for 100 days, maybe for 20 days, opposition political party would be having this particular right that they would be deciding that what all issues the House would be considering. Why we are witnessing frequent disruption? Because in Indian parliamentary system, it is the ruling government only which decides that what would be the agenda of the House. Opposition political parties, they have no say in that. And that is the reason they create ruckus in the House. Because they are not being allowed to raise whatever matters they want the House to look into. So, to avoid this, we can go with this idea of opposition days. All this thing would enable us to make sure that the laws that the parliament is creating are simple, effective, we don't have vague definitions, and whatever law we are creating, that is not ending up in the court as litigation. Now, based on the discussion, please try and practice this mains question that I've created for you people. With this, let's move on to the simplified section. So now, beginning with the simplified section, recently, the Delhi High Court has clearly stated that Delhi University need not disclose the degree-related personal information which pertains to Honorable Prime Minister Narendra Modi. This particular topic we can associate with the polity section of a prelim syllabus. So, somebody would have filed an RTI application. In this respect, in 2016, an order was issued by the Central Information Commission to the Delhi University that you have to disclose this particular information, okay, degree related information which is pertaining to Honorable Prime Minister Narendra Modi. But the Delhi High Court has clearly stated that since this degree related information which pertains to Narendra Modi is falling under the ambit of personal information which is protected under Section 8, Clause 1, Subclause J of the Act, as you can see here. And such personal information could only be disclosed only when the disclosure of that information is going to serve the larger public interest. So, the public interest should outweigh the privacy of that concerned individual. And nothing of that sort is happening when it comes to this particular information. That is the reason the Delhi High Court has clearly stated that Delhi University need not disclose this degree related personal information which pertains to Narendra Modi. Now, we need to understand certain prelim pointers with regard to this particular act. So, this act was enacted by the parliament way back in 2005 and it came into picture because of the movement which was carried out by Mazdoor Kisan Shakti Sangathan, and it was also a result of judicial emphasis on the right to information. In State of Uttar Pradesh versus Raj Narayan case of 1975, Supreme Court clearly stated that right to information is a part of Article 19, basically freedom of speech and expression. And what is the sole intent of this particular act? Basically to enable the citizens so that they can get the information from the public authorities. Because when you will be having the information, only then you can hold the government accountable. Okay, so it intends to empower the citizens in this respect. Then, as we have discussed, that this act is derived from the fundamental right of freedom of speech and expression which is provided under Article 19, which is the coordinating agency. So, it is your Department of Personnel and Training which functions under Ministry of Personnel, Public Grievances and Pensions. What is the institutional framework? So, we have central and state information commissions which oversee the implementation and the appeal mechanism with respect to non-disclosure of information, and with every public authority you will be seeing central public information officers or state public information officers, okay, depending the fact that whether that public authority has been created by central government or the state government, okay. They are the one who would be providing you the information pertaining to that particular public authority. Now, what is public authority? Time and again I'm speaking this particular word. So if you go by the RTI Act, public authority includes all that authority which is created either by the Constitution of India, or it has been created by an act made by the parliament or the state legislature, or a authority which is substantially being financed, controlled and owned by the central or the state government. Okay, by that definition, NGOs can also be categorized as public authority if they are being substantially being financed by the central or the state governments. Now, what is the time frame within which I will be provided with the information? So normally it is 30 days, but if somebody's life or liberty is in danger, then in that case the information needs to be provided within 48 hours. And what happens if I don't get the information within the stipulated time frame? Then I have the appeal mechanism. So I can file an appeal to an officer which is senior to rank with respect to this public information officer, okay, in that particular public authority. Now you need to make note of the exemptions which have been provided under section 8 of this particular act. Okay, what all information would not be disclosed to you even when you file a RTI. If the disclosure of that information is going to severely affect the sovereignty and integrity of the state, its friendly relation with other countries, it is going to impact the economic interest of the state, relation with foreign state, or it leading to incitement to an offence, in that case the information would not be provided to you. Or if disclosure of that information has been expressly forbidden, okay, it has been denied by the court, then in that case also the information would not be provided to you. If disclosure of that information would lead to breach of privilege of parliament or the state legislature, or if that information deals with the trade secrets or intellectual property, so if we disclose that information, that would be harming the competitive position of a third party. In that case also information would not be provided to you. Or if the government of India has received some confidential information from other countries, that information would also not be disclosed to you. If disclosure of a particular information would put the life of a particular person in danger, in that case also the information would not be provided to you. Or if disclosure of that information is going to create a hindrance in the process of investigation, then in that case also information would not be provided to you. And the important section that today's current affairs is dealing with, if any information is related to personal information and disclosure of that information is not going to serve any larger public interest, okay, and this has been, personal information has been protected basically to preserve the right to privacy, which has been declared as a fundamental right in the Puttaswamy judgment. But one more thing that you need to make note of is, that is section 8 clause 2, which clearly states that the information could be provided if the larger public interest is being served. So if the public interest is outweighing the harm being caused to the privacy of that particular individual, in that case information could be disclosed. But we need to see that whether larger public interest is being served, and that is not the case when it comes to the degree related information with respect to Honorable Prime Minister Narendra Modi. That is what is the stand of Delhi High Court. Now, what are the key provisions which are there in this particular act? So we have section 4, which imposes an obligation on the public authorities that they have to maintain the record in such a manner that providing information becomes very smooth. Then section 6 state that if you want to get the information, then you make a request in writing to the central or state public information officer, okay, wherein you need to specify the particulars of the information that you want. Then section 7 basically talks about that what would be the next course of action if the information is not provided to you within the stipulated time frame. So in that case, section 19 clearly states that if the information is not provided, what you will be doing, you will be filing an appeal to an officer who is senior in rank to the public information officer in that concerned public authority. That is what we discuss. That's all that you need to know with regard to this particular topic. Let's move on to the next one. Now, recently a write-up has appeared in The Hindu wherein the writer is talking about that how in the recent times we are seeing severe curbs on press freedom. This particular topic you can associate with GS paper 2, government policies and issues arising out of their design. Now, initially the writer is pointing out that although press freedom has been recognized as a right by the Constitution bench of the Supreme Court in the Romesh Thapar case of 1950, But in the recent times, what we are witnessing is that this press freedom is being severely curbed. Why the writer is saying this? Because recently an FIR has been, lodged in Guwahati, Assam against journalist Siddharth Vardarajan. Why? Because some content that he has written, some video that he has created, according to the police official, that is spreading narrative which is aligned with hostile interest. Okay, so the FIR is also not very clear. And in this particular respect, the Assam police is also questioning two other journalists. Okay, although Supreme Court has provided a short-term relief. How come? Supreme Court has directed that no coercive action should be taken against these journalists. But the writer is making a point that in the short run, okay, this directive given by Supreme Court is fine. But in the long term, this is going to lead to collateral damage. How come? Now, first you need to understand that although when we came up with the Bharatiya Nyaya Sanhita, we said that the offence of sedition has been removed. But even though we have section 152 of BNS, which creates an offence of endangering the sovereignty, unity and integrity of India, just like the sedition thing, then when it comes to this particular section of BNS, herein you could be provided with the punishment of life-term imprisonment. Why? Because just expressing dissent against any particular government action would not be considered to be threatening the sovereignty and unity and integrity of India. It needs to also be backed by an armed rebellion, subversive or separatist activity. Okay, just merely if you have written an article which criticizes the government, that cannot be constructed or cannot be perceived as endangering the sovereignty and unity of India. But the writer is pointing out that how recently we are seeing the curbs on press freedom and what are going to be its long-term impact. First and foremost is the chilling impact on freedom of speech and expression. So the writer is making a point that let's suppose an interview is going on and some journalist has criticized some of the policies of the government. Now somewhere somebody in the country would be construing that particular viewpoint as going against the national security and a case could be filed. So this is one thing, that how we are curbing the press freedom. Then second issue that the writer has pointed out with respect to what is happening in the state of Assam is how this is creating financial inconvenience to the journalist, because a frivolous complaint has been filed against them and they are the one who have to bear the litigation cost. They have to pay the lawyer's fee, and if they are not residing in the state of Assam, then from their resident state, time and again they have to travel to Assam. So they have to bear the travel expenses also, boarding, lodging expenses also. And there is no guarantee also that questioning would be done in one day. Maybe when they reach Guwahati, the policeman would say that we have some other important case to investigate, you come some other time. Okay. So unnecessary, the journalist or against any ordinary citizen against whom such frivolous complaints have been filed, that person has to unnecessarily bear the financial cost. The writer is making a point that since this complaint has been made by the state, why it should not happen that the officer should travel where the accused is ordinarily residing, so that ultimately the expense should be borne by the state and not the journalist or the ordinary citizen against whom the frivolous complaint has been filed. And another point which the writer is pointing out, that why can't we consider the option of video conferencing? Recently, the Delhi Lieutenant Governor has allowed the use of video conferencing to cross-examine the police officer in a criminal trial. So the writer is questioning that why can't the same thing be applicable to journalists? And one added advantage of this video conferencing thing is everything would be done in a transparent manner. We would be having an electronic record of that thing, and the investigative agencies could not accuse the journalists that they are not cooperating in the investigation. Okay. Now, another concern which the writer is pointing out with respect to whatever is happening in Guwahati and Assam, that how the actions of the Assam police force, they are going against the court judgment as well. So the Supreme Court in Youth Bar Association of India 2016 judgment has clearly stated that an accused needs to be given a copy of the FIR. And even the common sense tells you that if I want to, make my stance clear, I need to know the allegations which have been levied against me. And until unless I don't know that what all allegations have been made against me, what all charges have been levied against me, how will I make a legal representation when it comes to the court? And that is not happening when it comes to whatever is happening in the state of Assam. The two journalists who have been summoned by the Assam police force for questioning, they have yet not got the copy of FIR. They don't know that what all charges have been levied against him. Then another judgment of Karnataka High Court, that is Shri Tavaragi Rajashekhar Shiva Prasad 2024 verdict. Therein, the court has clearly stated that a copy of FIR needs to be filed with the jurisdictional magistrate. And that is also not something which is happening in this current case. Finally, the writer is making a point that God knows that how many more people would be summoned when it comes to this, current case which is going on against the journalist. Lastly, the writer is asking three prominent questions that should this section 152, which is more or less on similar lines of sedition of BNS, should remain regardless of the fact that whether it is constitutional or not. Second question is, should not the mandate of law be followed by the police? At least the police should follow whatever the courts have said in this, verdict. And should the state not being made accountable when it comes to these particular cases? Why should the journalist or the common citizens have to bear the financial inconvenience? State should be made more accountable. It should come forward and it should tell the people that what all allegations or what all charges have been levied against the journalist or the common citizen against whom the frivolous complaints are being made. Okay, that's all that we need to know with regard to this particular topic. Let's move on to the next one. Now, recently, the Union Home Minister has made a derogatory remark with respect to the opposition political party vice president candidate with respect to the Salwa Judum judgment that he has pronounced. This particular topic you can associate with the polity section. So, the Union Home Minister has criticized the opposition political party candidate for vice presidentship, that is Justice B. Sudarshan Reddy. And what allegations he have made against this opposition political party vice president candidate, that had he not delivered the Salwa Judum judgment, we would have been able to end the Naxal terrorism by 2020 only. Now, this has been severely criticized by the legal fraternity that judicial ruling cannot be equated with the personal views of a judge. And to find motive or personal interest of a judge in a given judgment is certainly not permissible. Now, let's just understand what is this Salwa Judum that was in practice in the state of Chhattisgarh. So, in the first decades of 2000, basically between 2005 and 2011, Chhattisgarh was one of the worst affected areas when it comes to Naxalism, and we saw extreme violence and death of a lot of people, especially in the Bastar region alone. Now, in response, the Chhattisgarh government came up with this Salwa Judum practice, wherein it mobilized local villagers to, form armed group of special police officers, also known as Koya commandos. These groups basically consisted of tribal youth of particular areas who were as young as 18 years old and had limited education. Now, there was quite discrepancy when it comes to Chhattisgarh Police Act and the Indian Police Act. When you go by the Indian Police Act of 1816, therein you need the approval of magistrate to appoint special police officers. But when you go by the Chhattisgarh Act, the superintendent of police has been given wide discretionary power when it comes to appointment of special police officers. Then, when it comes to this Salwa Judum practice in Chhattisgarh, herein the tribal youths were trained for self-defense. They were also provided with firearms and they used to get a honorarium of 3,000 per month. What was the benefit? Benefit was the state was able to increase the manpower on the side of the state itself, and these tribal youth were there to provide intelligence input to the police forces or regular police forces, because there were certain areas which were inaccessible for the regular police forces. So therein these tribal youths were helping. Now, what was the matter before the Supreme Court? So various people like the sociologist Nandini Sundar, historian Ramchandra Guha and former IAS officers, they filed a petition before the Supreme Court against the Salwa Judum practice. What were the grounds? They pointed out that this is unconstitutional practice as it's violated various fundamental rights like Article 14, Article 21. How it happens, we'll be discussing that in the subsequent slides, don't worry. And how it leads to human right abuses. And the petitioners pointed out that how this Salwa Judum practice, which was there in state of Chhattisgarh, it blurred the line between civilians and combat, because these combats were not properly trained to face such violent situation. That is the reason they talked about human right abuses. Now, what was the argument of central government as well as state government? So both the governments, central government, state government, they defended this particular policy. Central government stated that their role was limited to approving the upper limit of number of special police officers for each state for the purpose of reimbursing the money under the security related expenditure scheme, okay, which is one of the important scheme to deal with Naxalism. And the appointment, training, deployment, role and responsibility of the special police officers was with the state government. Now, the Chhattisgarh government in its detailed affidavit point out the reason that why we went with this particular practice of Salwa Judum. So it pointed out that recruitment was on voluntary basis. We did not force anyone to join the Salwa Judum thing. And the applicants were the one who have attained at least 18 years of age. They has to undergo character verification and they must be having the education qualification till 5th class. And the state was giving the preference to those who have already suffered at the hands of Maoist. So they would be helping the state in resisting them effectively. These officers were trained when it comes to use of weapons as well as law as well as human rights. They were equipped with firearms for self-defense and were also taught to assist the police and security forces for providing intelligence and guidance, especially in unfamiliar and inaccessible terrain. And the state of Chhattisgarh highlighted its effectiveness also, that how with this particular approach we were able to crack down upon various relief camps of Maoists, and it was instrumental in saving the lives of the regular troops also. And what welfare objective the Chhattisgarh state pointed out in its affidavit was that with this particular practice we are trying to create livelihood opportunities, because in the state of Chhattisgarh, especially in the tribal area, there is very limited employment opportunity. Now let's see what Supreme Court stated. Supreme Court first of all examined this particular practice of Salwa Judum, that whether it is in line with or it is violating fundamental right provided under Article 14 and Article 21. And what all issues the court highlighted? That this Chhattisgarh Police Act gave wide discretionary power to the executive when it comes to appointment of the special police officers without adequate procedural safeguards. Whenever you have wide discretion, you are likely that you will be abusing that discretionary power. If there is lack of procedural safeguard, then the chances of abuse are quite high. Then the court found that some of those who were recruited under this particular practice, they have not even studied till class 5th. So the court questioned that how a person who have not studied till class 5th could acquire appropriate skill that person could be used for counter insurgency movements against Maoist. They don't possess the analytical and the cognitive skills if a person has not studied till class 5th. The court questioned that how can you say that that particular person has the cognitive and the analytical ability to understand that what is this concept of self-defense all about, and you have given them the firearms also. They might use that firearm for other purpose. And the court found out that how this particular practice violated Article 14. Because it was expecting poorly trained and underpaid special police officers, because they were merely paid a horarium of 3,000 per month, to perform the same function which a regular police officer was doing. So it was discriminatory. On the basis of wage, it was discriminatory. On the basis of training also, it was discriminatory. And you are giving them meager uranium and you are putting them in a life-threatening situation. Similar to the lines of regular police officers. They are being paid adequately when it comes to the regular police force. But that is not the case with the tribal youth who were made a part of this Salwa Judum practice. So that is how it violated Article 14. Now how it violated Article 21? Because Article 21 talks about what? Right to life. And court pointed out that the tribal youth who were made a part of the Salwa Judum practice, they were made special police officers, but they were not adequately trained. When they were not adequately trained, how can you put such a tribal youth in a life-threatening situation? So that goes against the right to life. And the court questioned that how can you say that putting a tribal youth who is not adequately trained in such a life-threatening situation and you are making it a case of providing livelihood opportunity? What rubbish is this? So that is the reason Supreme Court ended this particular practice, and the court stated that how this particular Salwa Judum practice was going against human dignity. So it ordered the practice of appointing special police officers for counter-insurgency operation should be stopped. Okay, so ultimately this practice was disbanded, and the court pointed out that only and only properly trained regular police forces or paramilitary forces should be involved in counter-insurgency operations against the Maoists. So that was all that we need to know with regard to this particular topic. Let's move on to the next one. Now, recently a write-up has appeared in The Hindu, which is talking about the changes in India's Japan relationship and how we are balancing our relation with Japan as well as China at the same time. This particular topic you can associate with GS paper 2. Now, recently the Honorable Prime Minister Narendra Modi is going to visit Japan as well as China. And this visit become important because of the changes in geopolitics that we are seeing. Especially this is in respect of the Trump, additional tariff the Trump administration has imposed on Indian goods. And recently we are seeing easing of tensions when it comes to India and China. That is why this meeting becomes very important. Now, what all things we have planned when it comes to visit to Japan? So Japan has announced that it is going to invest roughly $68 billion when it comes to India over the next 10 years. So this would give a boost to infrastructure, manufacturing, clean energy, and this is going to strengthen the technology partnership between the Japan as well as India. And this also highlights that how Japan is seeing long-term stakes in India's growth story. Then next generation E10 series Shinkansen trains have been introduced under the Mumbai-Ahmedabad high-speed rail corridor. When you talk about this particular corridor, it would be starting from Bandra Kurla complex in Mumbai and it would be till Sabarmati. So it reflects what? Better economic collaboration, and it also highlights the Japan's willingness to transfer cutting-edge technology to India. Now what is this E10 Shinkansen bullet train? So it is Japan's next generation high-speed bullet train, as you can see here, and it has been designed by the East Japan Railway Company in partnership with UK-based firm. What are the key features? So it has L-shaped guides to prevent derailment during earthquakes, lateral dampers and advanced brakes to reduce shaking and shorten stopping distances, blowerless induction motor to reduce maintenance and enhance energy efficiency, autonomous ready design with flexible space for cargo transport in future, and spacious 2-seat per row configuration for comfort. And India would be the first country outside Japan to adopt this particular high-speed bullet train. And Japan is not just diversifying its economic footprint in India, it is also reinforcing the idea that dedicated long-term cooperation can deliver tangible outcomes. Basically, you will be getting the outcomes what you have actually anticipated. And we have planned that we are going to revise the Joint Declaration on Security Cooperation we are discussing with respect to Japan, keeping in mind the changing geopolitical realities, that how China is becoming more and more assertive in the South China Sea, how it is coming up with string of pearls in the Indian Ocean. So in that respect, the two countries have planned that they would be revising the security cooperation. Then we have proposed the Economic Security Initiative, which would be covering various sectors like semiconductor, critical minerals, pharmaceuticals, green energy, etc. And this would enable the two countries to realize the idea of diversifying supply chains. Okay, if Japan is ready to provide us with critical minerals, etc., this would help us in reducing our dependence when it comes to China. And we are planning to upgrade our digital partnership also. So the two countries have planned that we would be collaborating when it comes to artificial intelligence, startup ecosystem, etc. Now, the writer has pointed out the US factor, basically the Trump administration increasing the tariff, okay, when it comes to Indian goods entering the American market. So in that respect, India is trying to balance its relationship with Japan as well as China. Now, in this backdrop of Trump administration increasing the tariff when it comes to Indian goods, India is trying to ease its relationship when it comes to China. That is why the writer is saying that the time of visit is very important. After, visiting Japan, Honorable Prime Minister is going to attend the Shanghai Cooperation Organization Summit, which is going to be held in China. Now, tentative signs of stabilization after the Galwan clash that we witnessed in 2020. So, basically the writer is talking about that how we are seeing easing of relation between India and China also, keeping in mind the unpredictable Trump administration. Now, the writer is further pointing out that how this visit of Honorable Prime Minister, firstly to Japan, then to China, is highlighting that how India is trying to balance its relationship between China as well as Japan. Okay. India's ability to engage with a trusted strategic partner, that is Japan, and a neighboring competitor without allowing one relation to dictate over the other. So this highlights the strategic autonomy element as well. And this is also highlighting that how India can compartmentalize. With Tokyo, our focus is on advancing and strengthening our economic as well as technological partnership, okay, because we have the same goal of rule-based order when it comes to the Indo-Pacific. On that lines, we are collaborating with Japan. When it comes to China, our major emphasis is on de-escalation, okay, enhancing the confidence building measures, and we are keeping the communication line open. Okay, because the previous tensions still undermine the trust that we have on China. Lastly, the writer is pointing out that these two subsequent visits, what message they are trying to give. So the message that these two subsequent visits are giving, that India is strengthening its economic as well as digital partnership when it comes to Japan, because we see Japan as a like-minded country and we are guided by same goal, that is free and open Indo-Pacific. But when it comes to China, even in the backdrop of unpredictable Trump administration, we are easing our relationship when it comes to China. But even today, there is underlying mistrust. So the writer is pointing out that how India is using its diplomacy to maintain the strategic autonomy when it comes to balancing the relation between Japan as well as China. So India in future is going to strengthen its long-term partnership with Japan. That's all that we have to discuss when it comes to this particular topic. Let's move on to the last topic of today's analyst. Now, recently, we are witnessing famine-like situation in Gaza. This particular topic you can associate with the important international institution, basically, which is a part of your prelim syllabus. So, recently, a UN-backed integrated food security phase classification has come up with its report, and it has stated that we are witnessing famine-like situation when it comes to Gaza. It has pointed out famine-like situation only 4 times. In 2011 in Somalia, in South Sudan, we have seen famine-like situation in 2017 and 2020, and again in Sudan in 2024. The striking element of this particular report is the famine situation that we are seeing in the Gaza region. It is basically a man-made disaster. Okay, this famine is entirely man-made. So the report points out that this famine can be halted as well as reversed because it is man-made. It is not because of the climatic or natural factors. Previously also, it warned in July that famine-like scenario are unfolding in the parts of Gaza, but it does not give the declaration. But now it has given the declaration, because previously it was finding it difficult to gather reliable data. Now, this particular declaration obviously is going to increase the international pressure on Israel government. But in past also, what we can see is Israel has been dismissing the global criticism, pointing out that it is all Hamas lies. And previously, other bodies like Doctors Without Border, Oxfam, Amnesty International, they have also accused Israel of deliberately obstructing the flow of aid. So majority of the international bodies are pointing out that the famine-like situation that we are seeing in Gaza is a man-made famine. And Israel's blanket rejection of every report pointing out as Hamas propaganda is unlikely to persuade the international community in the long run. So international community is building up pressure on the state of Israel. How come? The occupation of West Bank by the Israel has been condemned by 26 countries as well as European Union. And the Israel decision to transfer its civilian population into the occupied territory is violating Article 49 of 4th Geneva Convention. Then various countries, UK, France, Canada, Australia, they have stated that they are going to recognize the state of Palestine in September. But the problem is, the only state which has the leverage when it comes to Israel, it is United States. And the United States is indifferent. It is not speaking a word when it comes to the famine-like situation that we are witnessing in the Gaza region. And rather, what we are seeing is, it is hinting at support for the settle plan, okay? Transferring the civilian population to the occupied territory. So, Israel is continuing this war because it somewhere has the support of USA. Now, in this respect, we need to understand what is this integrated food security phase classification. So, this particular entity is there to ring the alarm bells so that we can prevent famine and guide the adequate humanitarian response, so that we can prevent the famine-like situation. So, it basically assesses the hunger crisis in a particular region. It was created in 2004 by the Food Security and Nutrition Analysis Unit, which is managed by FAO of United Nations. It is an innovative 21 partner initiative which is made up basically of UN agencies and international NGOs. And how this particular entity gets the funding? So, it is majorly funded by the Western countries. It is overseen by 19 major humanitarian organizations and regional bodies, and it basically partners with the national government to get reliable data. Data collection method, it relies on UN World Food Program and other relief organizations and government agencies and the national government as well. And what is the preferred measurement for malnutrition? So, it would be assessing child's weight, height, and if not possible, mid-upper arm circumference is used. Now, how this particular entity declares that we are witnessing famine-like situation in a particular area? So, it has a 5-phase scale classification. The 5th phase is the most severe phase. Famine basically relates to a wider area. Catastrophe deals with the individual household level. Now, if this particular entity or any of its partners find that at least one area is in famine, then a review committee which would be consisting of 6 experts would be created to finally take a decision that whether this area is affected by famine or not. Now, on what basis that committee would be reviewing that whether a particular area is witnessing famine-like situation or not? So, we will be seeing that at least 20% of the people must be suffering from extreme food shortages, with 1 in 3 children should be malnutrition, 2 people out of every 1,000 people should be dying daily from starvation or malnutrition and diseases. If any of these conditions is satisfied, then this review committee would be created, which ultimately would be taking a decision that whether that area is affected by famine or not. Now, one important thing that you need to make note of, because this could be made a statement when it comes to prelims question, that this particular entity does not formally declare famine, but it merely provides the analysis for governments and agencies. It basically is there to ring the alarm bells so that we can prevent the humanitarian crisis. Now, since the article basically talked about Geneva Convention also, let's have a discussion over that as well. So these are basically a set of international treaties that establish the legal standards for humanitarian treatment of civilians, prisoners of war, etc. during the war. So it forms the core of international humanitarian law and aim to limit the suffering of the people who are no longer part of the war, such as civilian, the wounded soldiers, prisoners of war, etc. And it was formalized in 1949 by the United Nations after the Second World War. Now, there are 4 Geneva Conventions. The first convention intends to protect the wounded and the sick soldiers on land during war. Second Geneva Convention deals with the sick and shipwrecked military personnel at sea during war. Third Geneva Convention deals with prisoners of war. And fourth Geneva Convention deals with protection of civilians, including those in occupied territory. Okay, and the plan of Israel to transfer its civilian population in the occupied territory is basically a violation of fourth Geneva Convention. That's all that we need to know in today's Analyst. It would be coming right up next. So don't forget to practice the quiz and check your knowledge. Till then, keep smiling, keep learning. Have a great day, all of you.